Good morning, good afternoon, everyone. For those of you that have dialed in, we're going to give a couple of minutes to let some of the other folks that are now registering and logging into the BrightTalk platform. So I appreciate your patience. Give us, again, about 2 or 3 minutes after the hour, and then we'll get started. Thank you. Okay, well, good morning, good afternoon, wherever you are in the world. Thank you again for taking time out of your busy schedules and joining us today. The title of the webinar is GDPR Compliance. What does it take? Are you ready? We have a number of experts here joining us today, but I do want to go through the agenda. I'll introduce who I am as well as the other speakers. And again, for those of you that are listening on the lines here, your lines will be muted. I'll be providing some additional housekeeping instructions to you shortly. So we'll go through introductions. We'll talk about the GDPR regulation, what you need to know, the solution approach, leveraging Informatica's portfolio and solutions around GDPR compliance, as well as some of the expert services provided by Paradigm Technology, which we're doing, again, an introduction as to who they are, the speakers here today. And then finally, we will wrap up the session with the time remaining for questions and answers from the audience. Housekeeping items, Housekeeping items. So again, all lines will be muted throughout the webinar. Questions can be submitted via the BrightTalk application. So for the audience members, if you look toward the right hand of the screen, you have the ability to submit your questions to us. Again, we'll be then going through the questions that are submitted at the end of the formal presentation. We'll also be including a copy of these slides as well as additional links to GDPR-related resources after the webinar to everyone who is attending today. So legal disclaimer, of course, we can't get around these days without disclaiming what we're going to be talking about. So compliance with the Global Data Protection Regulation will be based on the specific facts of an organization's business operations and use of data. This webinar provides a set of discussion points that may be useful in the development of an organization's GDPR compliance efforts and is not intended to be legal advice, guidance, nor recommendations. An organization should consult with its own legal counsel about what obligations they may or may not need to meet. So now, since we're done with legal disclaimer, let me go ahead and introduce the speakers today. My name is Peter Koo. I'm the Vice President of our Financial Services Industry Consulting practice. For those of you that are joining and not familiar with Informatica, we are the leader in the enterprise cloud data management space. We recognize the impact GDPR may have on your organization, and we have a unique set of integrated products and solutions for data governance, data protection, data management, consent, and rights management. We also have Mohit Sehgal, who's the Vice President of Paradigm Technologies Analytics practice. Paradigm is a boutique strategic consulting company serving banks, airlines, utilities, high-tech manufacturing, and retail here in North America as well as abroad. And Paradigm focuses on assisting clients with analytics, risk, governance, compliance, and digital transformation programs. And finally, we have Paul Sinelli, and representing Paul Sinelli today, we have Jarno Vanto, who's a shareholder, and Paul Sinelli is an American law firm with more than 800 attorneys and 20 offices. And Paul Sinelli's core practice areas include global privacy and cybersecurity compliance programs and cross-border and domestic intellectual property licensing and other technology transfer agreements. So these are the three presenters today. And what I would like to do at this point is hand over the microphone to Jarno Vanto. Jarno?
Hi, everyone. Good morning, good afternoon, wherever you are. Great to meet you all. GDPR is about 88 pages of printed material, so I'm pretty close to a world record here if we can cover everything in 15 minutes, but hopefully we'll capture some of the essential points relevant to everyone on this call this morning. Here we go. All right, GDPR, what, when, and why. So the GDPR stands for the General Data Protection Regulation. The European Union has had laws in the books about personal data since the mid-90s. The current law that now steps aside and is replaced by the GDPR is called the EU Data Protection Directive. And the GDPR enters into force on May 25, 2018, and so we have about 2 months exactly almost before the GDPR is enforced. Why it's made such headlines globally is that the fines will have a bite. So non-compliance will or may ensue in resultant fines of 20 million euros or 4% of the company's global revenue, whichever is higher. So we're looking at significant non-compliance risks. And in order to understand, there's a lot of GDPR-specific jargon, and briefly walk through the basic concepts of GDPR so that everyone on the call understands what we're talking about here today. So first, the concept of personal data. So personal data is anything relating to identified or identifiable natural person or human being. So for example, corporate information is generally not personal data. The personal data is understood very broadly. So for example, not only things like names, social security numbers, or things that are directly identifying a person, but also broadly understood, for example, cookies on websites, mobile device IDs, things like that, that online businesses and mobile businesses collect are also considered personal data, as are IP addresses. It's been found by European courts a number of times, for example, that IP addresses are personal data. So very broadly understood concept, broader than the U.S. concept of, for example, personally identifiable information. And the concept of processing really captures any type of activity that you do with personal data, storing, transmitting, accessing, any of those processes that relate to what the company does with personal data. And a data controller is the entity that determines the means of processing personal data, how personal data is processed, and the purposes for which data is processed. So, for example, when you collect personal data as a company, for what purposes you're collecting it. If you're determining those purposes, you are what is called a data controller. And companies can have dual roles. For some types of data, for example, their employee data, they can be a data controller. But for example, if you're a vendor and you're dealing with your customer's personal data, you're a data processor because your customer determines the purposes and means of processing, and you're processing the data on your customer's behalf. So you're a data processor. And moving on, we will cover who is impacted by the GDPR. The GDPR has a broad reach. Basically, the simplest case is, for example, if let's say that you have an affiliate in the European Union, the 28 member states of the European Union, you're clearly captured by the GDPR. Or if you have customers in the European Union that use your services or order products from you online, you're captured by the GDPR. But if you're offering goods and services to Europeans, for example, online or mobile, you're also captured by the GDPR. GDPR really captures companies in all types of industries, for-profits, non-profits, companies may be surprised to realize that they are captured by the GDPR, but it has a really broad reach. And next, we are going to cover GDPR basic compliance issues. There's a lot of ground to cover. As I mentioned, it's 88 printed pages, so we're going to focus on some of the key concepts relevant to the audience today. One of the things that the GDPR requires is that any processing of personal data must have a legal basis. What that means typically for private for-profit corporations is, for example, that you have a contract with your customer. So that contract gives you the legal basis to process personal data. Or you have obtained consent from the person to process their personal data. For example, in a web form or mobile, but you have consent from the person to process their personal data. And this concept of consent, has really been discussed quite a bit lately. But one thing that I would like to remind the audience here today about is that consent is not the only legal basis to process personal data, and it may not even be a suitable basis in many instances for processing personal data. So while the discussion has been around consent, is not the only legal basis to process personal data. It's one of the legal bases to process personal data. But when you use consent under the GDPR, it really has to be obtained freely, has to be informed, so the person actually needs to know the purposes for which you're processing their personal data, has to be freely given, and it can't be bundled into the terms and conditions of a website or a privacy policy. It has to be separate from the legalese on mobile and online platforms. And then there's what is called a legitimate interest. So your company, for example, may have a legitimate interest to process personal data relating to your, for example, customers. So, for example, the email addresses, you might have a legitimate interest to retain email addresses of your customer contacts so you can send them marketing communications. One key to remember about legitimate interest is that persons can oppose your company's processing based on legitimate interest, so they have a legal right to say, I don't want your company processing my personal data any longer based on your legitimate interest. I want you to stop, and the company generally have to comply with that request unless they have another legal basis to process personal data. So those are the key legal bases to process personal data under the GDPR. There are others that might come into play. For example, in the one additional thing about employee personal data, for example, a lot of debate around whether employees can consent to their processing of their personal data. Generally, the view is that they can't because they don't have a choice. If they say no, what are the consequences? So employee personal data can generally not be processed based on consent, with some exceptions. And then one of the key challenges of the GDPR, and the folks at Informatica and Paradigm are going to be talking about those later on the technical solutions around this, but a lot of this, GDPR grants broad rights to what are called data subjects, so the individuals whose data companies process, and so-called data subject rights. And for example, one of those rights is the right to access personal data. What that means is a person calls your company and says, "I want to know what data you hold about me, and I would like to get a copy of the personal data that you have about me, and to, for example, verify that it's correct," or a number of other things. But before you can do that, at a system level, you have to identify where personal data resides in your system. Otherwise, you cannot comply with that request. So you have to be able to identify in your systems where personal data, broadly understood, resides. There's been a lot of talk also about the so-called right to be forgotten, and that doesn't apply in all instances. It broadly applies, for example, in situations where you process personal data on consent, the person's consent, and then the person then later withdraws consent, and then you must delete the data from your systems. Or a person's data has been processed based on legitimate interest, and they say no, you got to delete the data from the system. It doesn't apply in all instances. For example, if you have a legal obligation to maintain data, for example, because of, for example, tax reasons, then the right to be forgotten doesn't generally apply. And then the issue of data transfers. So this is often a question that U.S.-based companies, for example, face. If they receive, for example, or access data through an HR database system of the company, and that the HR database includes data relating to their European employees or their European customers, employees, or they have a CRM system that has information about the European customers, then what the company is doing from a legal perspective is transferring the data from Europe to the United States. And in that context, the U.S. is not considered as a country that provides adequate protection for personal data. The EU thinks so, and therefore, your company must have a legal means of moving that data from Europe to the U.S. One of the most generally available means for doing that for U.S.-based companies is the Privacy Shield. Another method of legalizing those, if you have an EU affiliate organization in Europe, is to enter into so-called EU Commission standard mono clauses. And if you don't comply with these transfer requirements, that's one of the most heavily sanctioned violations of the GDPR. So please make sure that you have a legal means of moving data from Europe to the United States. And running out of time here, but I did want to touch upon, for example, the concept of data protection impact assessment here. So what that means is that if you're engaging in activities around personal data that have a significant impact on user privacy, for example, if you're an online business that's tracking the consumers online across websites or across devices, things like that, for example, or if you're in the business of processing health data, and you're thinking of new ways in which you can tap into the data, for example, building a new data product, you have to engage in what is called the data protection impact assessment. So you actually have to look at the privacy impact of your activity, see what type of impact it has, what kind of changes you can make into the product in order to make it less privacy invasive, and you have to record that process as a compliance effort. And what I did also want to emphasize before we run out of time here is that the GDPR is not primarily about doing X, Y, and Z and becoming compliant on May 25. it is about building processes for ongoing compliance efforts. So, for example, data protection impact assessments are a process. You have to build that at the company level in order to stay compliant. And then one of the things that GDPR often there's a talk about data protection officer. So, for example, what kind of companies have to appoint a data protection officer? Companies that, for example, monitor individuals on a large scale. So, for example, online tracking companies, similar or health data tracking companies, or companies that process sensitive personal data. So, for example, health data on a large scale have to appoint a data protection officer. So that leaves out a large chunk of companies that don't have to appoint a data protection officer. Finally, fines. Fines, as I mentioned, are going to be significant. I don't think, though, that the regulators are going to be coming out of the gates starting to impose large fines on day one. There will be a period where they're looking at the company's compliance efforts, assessing what's going on the ground before those big fines are going to be in the headlines. So that is my part. Thank you very much for listening.
Great. Thank you, Jarno. So let's talk about some of the solutions for GDPR compliance. And I will go through the portfolio solutions that Informatica is offering in the marketplace. And I apologize for the sequence here. Let me make sure I got control of the slides. All right. So GDPR, when we look at the requirements, the foundation for a GDPR journey is really the ability to define policies, processes, and the stakeholders for GDPR compliance. It's important for customers to know what data they hold, who has access to it, and for what purpose. So we're really dealing with the data aspects of this regulation. In addition, organizations need to discover the data to protect and manage, right? How do you know what to protect? How do you know how to answer the questions the regulators may have if you actually don't know where that data is? And therefore, they need to determine where all their in-scope data resides across the enterprise, both on-premise, as well as we all know, many organizations are investing and extending their computing capabilities, their data storage capabilities into the cloud. Next, based on the organization's goals, it's important to really understand how they manage, protect, and monitor all this data. You know, a customer might need to control access to data and determine how to protect data and apply appropriate controls. In addition, organizations might want to centralize their data across an organization. A key question they have is really around managing the consent rights and enacting rights. So how do you do that? As you can see, these approaches are strategies for dealing with the new requirements from this or for this regulation. However, adopting them can leave companies in a better place overall in terms of their broader data management needs. So we'll go into each of these areas in terms of what they are and how Informatica addresses it with our portfolio. Now, the business outcomes really are number one. As you have the ability to govern and understand what data you need for this regulation as well as others, it really helps from a compliance standpoint to be able to get the data that you need quicker, be able to really look at where those risk exposures are. So you're building efficiencies, but more importantly, you're building more accurate ways of dealing with the regulatory reporting requirements and what the organization needs to protect their EU citizen data. Data discovery for other policies is really about making sure that the organization understands where their data is. I mean, this is very important, not just for complying with this regulation, but for all the other risks of having an unwanted data breach and ending up in the headlines. We don't want to obviously have those situations occur anywhere in the world. You want to have applications that are obviously secure. When you are using data for testing and development purposes, you need to obfuscate sensitive information, personally identifiable, non-personally identifiable information, so that if anything goes bump in the night, a laptop gets stolen or password gets breached, that that information, that valuable information used in test data is secure. And then finally, being able to understand who your customers are. How are they related to each other? Because that one person that you may be marketing to in Europe may also have relationships with other customers, prospects, as well as employees within your company. And therefore, you have to have the ability to understand who they are and how they're related to each other. And this is where Informatica has 4 solutions that we're going to talk about today from a GDPR compliance standpoint. So under the define and discover areas, number 1, definitions. What data do I need to comply? Who owns the definitions? Where should we be using this information in order to run our business as well as to deal with these regulations? And that's handled by our data governance solution called Informatica Axon. Number 2, sensitive data discovery and risk management. This is, again, about being able to understand where that data is, where it resides, where it's proliferated, and that is addressed by Informatica Secure at Source. Down below, Informatica Data Masking and Archiving deals with the anonymization of sensitive data, both in test data as well as in production systems, but also being able to say, what data do I want to archive or purge? Because I want the ability to delete things or put them in a secure storage platform, and not necessarily have to have human beings involved in that process. And then finally, for consent mastering and enacting rights, Informatica Master Data Management allows you to have a trusted source of information about your customers, your employees, your prospects, and of course, being able to define those rules to determine how they're related to each other. So we're going to dig into 4 of these areas and give you a sneak peek in terms of what they actually do and how they're used. So let's go into data governance. Data governance for GDPR is really about being able to have data stewards collaborate with business counterparts, whether on the compliance side of the organization or elsewhere, being able to define those policies together, being able to define what that data means, those business terms and definitions together, so that downstream data consumers can then understand and consume and really understand where and how they should use that data. They need to have the ability to also collaborate with each other. Very important, because when you're publishing information about a data attribute used for regulatory reporting, and business changes, people may actually have different definitions and points of views. The aspect of governance is being able to have the collaboration between data owners, data stewards, and data consumers. Now, this is important not just for GDPR compliance, because at the end of the day, data governance, as we all know, in industries where data governance is more mature versus those that are just getting started, you have to have the ability to really treat data as a business asset. In order to do that, you have to have the ability to collaborate and to define policies and definitions for the data that you're using, not just for compliance reasons, but also for revenue reasons, for customer relationship reasons, given the fact that data has value and it has to be managed and governed. So Informatica Axon for data governance, and specifically for GDPR, really for 2 types of users. Data stewards are going to be responsible for defining the terms and definitions of what that data means, how it's used for GDPR compliance through Axon. So business glossaries, data policy management, and then down below, they also have the ability to define the business lineage, not the technical lineage, but how does that information get utilized across the organization and for what purposes? Where is it coming from? And then finally, the approval workflow allows stewards to then define, well, if terms have to get updated or there are requests being made by the business to change a definition, that they can actually predefine what those workflow processes are through a built-in workflow capability. And then the business users, again, they're consuming and collaborating. They're consuming views of, can I trust the data that I'm using to comply with GDPR? And that's done through scorecards that we have integrated with Axon. You have the ability to then view definitions and the catalog of the data that's being used for compliance, viewing that data lineage. Where is that data coming from? Who owns it? What are we doing to the data as it hops across the enterprise? And then finally, at the bottom right, being able to make those change requests and communicate with other stakeholder groups as well as other data consumers about the assets and the artifacts that are being maintained in our Axon platform. So this is data governance for GDPR compliance and beyond, addressed by Informatica Axon for data governance. On the data privacy and protection side, Jarno talked about the need to protect, being able to identify, but also be able to obfuscate and mask sensitive information. Now, we're addressing this in our second component of our GDPR portfolio of solutions, which is being able to manage sensitive data discovery and also understand the risk exposure from all of the sensitive data that's floating around, residing in the systems and applications in your organization. You have to have the ability to really understand where that data is. And really from an approach standpoint and best practices, you can't begin assessing where you need to take action, what the exposures are for the potential gaps that you have, unless you actually go through this process. And as we mentioned again, it's not just for GDPR compliance, it's also very important to protect sensitive information from thieves, from the bad people out there, but more importantly, to comply with other local and regional data privacy regulations here in the U.S. and abroad. Now, data privacy, we talk about secure source as the solution. We'll also show you kind of what that looks like. The first thing you want to do is be able to scan and identify where's all my data. We have the ability to connect to systems, and we are able to determine, hey, is that a social security number field, or is that a passport number versus a zip code and or a phone number in a particular country. We also then, once we know where that data is and what it is, we then have the ability to determine, where is that data being used? Who has access to it, right? So we can do and provide user analytics. We also provide proliferation analysis. So yes, I have, for example, information about my customers, and we have, for example, the country of which they are citizens, but where is that data proliferated? Who copied it? Where has it gone across the various systems, both within the firewall as well as outside the firewall? And then from there, you then have the ability to then analyze your risk exposure and being able to really provide those dashboard views. So, for those that are in the role of a data protection officer, you need to know this. And it's very difficult to build these types of solutions from scratch or bolting on existing business intelligence applications to provide these dashboards and views. And looking at the sensitivity of where your sensitive data resides on a real-time basis and across the enterprise. And these are just some of the screenshots that you're seeing here from our secure end source solution. Data archiving and anonymization. Pretty self-explanatory when we talk about archiving and anonymization for GDPR, right? What do you need to do in order to protect, but more importantly, get rid of that data if you're being asked to delete it, right? The right to be forgotten. Again, the approach is it has to be really looked upon as an enterprise-wide approach. If you just look at it within one application or one department, it doesn't necessarily solve or satisfy what GDPR is asking for, because GDPR is not at a project or an application or department level. It's at a company level. You have to have the ability to then say, well, what data should I delete? How do I delete it? Or can I just retain it and move it offline from the actual production systems in which it got created or it's currently maintained or residing in? How do I mask and archive, mask and protect sensitive information? Again, beyond GDPR, very important, because you have to think about what other data do I need to anonymize and mask? What other data do I need to archive and potentially delete beyond GDPR compliance? And we're doing this from an Informatica standpoint with our solutions, both for anonymization, which is handled by our masking solution, as well as what we call erasure, which is ultimately to be able to delete that data that you're requesting without, again, as I mentioned earlier, having human beings maintaining those rules and policies to say what data do we need to delete. It's all about automating that process so that you're reducing the cost of managing your data in order to comply with GDPR. In scenario one, what we're talking about here are two types of masking capabilities that we offer. One is what we call static masking. So what we're really talking about is masking data from production systems that is used for testing and development purposes. And what we want to do is identify the PPI, NPI fields and be able to apply proven masking rules to then blur, to substitute, to anonymize, to ensure that that data is free of being leveraged for bad purposes, but being able to then provide the data that testing and development teams need and retaining the data relationships in that test file. Dynamic masking is about masking data in production systems. So as we have different folks in the organization, some may be allowed to see certain information, other people are not. Instead of creating copies and masking, what we're doing is we're applying those masking policies on the fly. So if people are querying the same database, we have the ability to detect who they are based on their user login profile at the database level and be able to then mask information if those individuals are not allowed to see it. Scenario 2, erasing and deleting data that needs to be deleted in order to comply. We have the ability to automate archiving to a second-tier archiving platform of your choice, whether it's file or database related, or we can apply those policies in order to basically delete or purge that data out completely. And so that is handled by Informatica solutions or archiving solutions here on the right-hand side. Okay. Subject rights and consent management. So the fourth pillar of GDPR compliance, right? Do you know whether you have consent to hold and use this data to begin with? The approach, again, has to be enterprise-wide. It can't just be within that department, as we talked about. And you can't just look at one type of data. It has to be all entities. And the definition of entity is either an individual or non-individual. The data has to be obviously reliable. The issue that we find in many organizations in financial services, in particular, is that organizations who grew up in traditional business silos, they have copies or they have systems that support one area of the business. Customers define and manage and created across multiple systems for the same entity, and you start dealing with duplication issues. So how do you then trust one source versus the other? You need to really have a single source of that truth. And number two, being able to have a holistic view of that information and that relationship. Not only do I know who you are, but what do I know of our relationship with that individual across all the various lines of business? And data warehouses have never really been designed to do that, to support operational data synchronization. And that's where technologies like master data management come into play. And of course, being able to define those relationships between an individual versus other individuals, very critical in terms of ensuring that you have what you need to know in order to determine whether or not these individuals, these relationships are subject to GDPR. So the consent management challenge that we see here is really, processing rights need to be formally managed, right? Initially, organizations go for the simplest approach. Consent needs to exist for all sensitive data, not just, let's say, their CRM application. And if you did not adapt to each application, assuming you could, how would you use synchronized consent information across all of these systems and being able to ensure the consistency in enforcing that? And that's really the challenge there, because at the end of the day, as I mentioned, a lot of different systems have their own version of the truth. How do you know which source to really trust in order to determine what you need to do next from a data governance perspective? And this is where Informatica combines master data management to provide that single trusted view of your entity information, to be able to determine the holistic view of the relationship that you have with those entities. And then third, being able to determine how are these entities related to each other. And that's all handled by our master data management capabilities, which also leverages our data quality solutions in order to validate contact information. And then the workflow built into our master data management platform allows you to then determine what next steps do you need to take in order to support some of the consent management requirements under this most important regulation called GDPR. Okay. Now, with that said, I've gone through 4 solution areas. I want to hand it over to Mohit Sehgal from Paradigm to help all of you on the phone understand who is Paradigm and what they do around this area of GDPR compliance. Mo?
Very good. Thank you, Peter. Moving on to the next slide. My name is Mohit Sehgal, and I lead the analytics practice at Paradigm Technology. Paradigm is a 25-year-old boutique consulting company based in Phoenix, Arizona, with satellite offices in Chicago. We've had a strategic relationship with Informatica for many years and achieved Partner of the Year awards in 2005, 2015, and 2017. We have deep expertise in the Informatica platform, including several key product engineers and original architects of the product suite are now at Paradigm, including Winston Shea, one of the co-founders of Cyperion. Winston actually leads our MDM practice. In addition, we've recently hired Malik Aziz. Malik leads the PIM practice. So we have very deep expertise in MDM. Collectively, the Paradigm team has implemented some of the largest data infrastructures for some of the world's largest companies across several industries. From a GDPR perspective, working with Informatica, we have several experiences, including a large U.S. healthcare provider, large U.S. network equipment manufacturer, global casino operator, German commercial bank, Australian government, UK government, global cruise operator, just to name a few. And through these experiences, we've identified several themes across these clients. One, difficulty in identifying personal and potentially sensitive data that exists potentially across several hundred different types of data stores. Automating the impact analysis to reduce the invasive nature of data discovery, data lineage, data profiling, and data quality. Tracking events, communications, and mastering subject consents and rights in one place, critical. And finally, establishing the necessary data risk mitigation strategies and controls as part of an overall data governance framework. As a result, as Jarno indicated and summarized several aspects of the regulation earlier, again, working closely with Informatica, we've established several accelerators to assist organizations. One, conduct an initial and ongoing data protection impact assessment. These is covered by Articles 35 and 36. Establish the requisite data governance infrastructure, including data protection officer. I noticed that one of the questions earlier was, does the regulation require the anointment or appointment of a data protection officer? And the answer is yes, and those are covered by Articles 37 through 39. Establish the data architecture and self-service capabilities we believe are necessary for effective subject consent and rights management. Conditions for consent are covered in Article 7. Other subject consents and rights are covered in Articles 12 through 23. And as Jarno indicated, the lawfulness of processing, another critical aspect, is covered in Article 6. Program management is essential, helping to ensure that there's a comprehensive program that addresses the article's gaps and risks identified by the data protection impact assessment. And finally, data management, to help improve the underlying data infrastructure to reduce operational risk and improve customer experience. One of the things that we would suggest in both reviewing and understanding the articles and associated recitals, there are two good references. The first is the GDPR Compliance booklet available for download at the Informatica website. This summarizes the major regulatory themes. And then second, the UK Information Commissioner's Office, or ICO, one of the many data processing authorities in the EU, which has established several practical guidelines for interpretation of the regulation. Both of these are highly recommended as a follow-up to this webinar. After the webinar, you will get the details of not only the content presented here, but as well as the links to these two additional pieces of information. I believe the lines are now open for questions, so I'll conclude here and refer it back to you, Peter.
Great. Thank you, Mo. Thank you, Jarno. So the questions, again, the lines will remain muted. From the audience, if you do have questions for any one of us, please go ahead and use the BrightTalk application to submit your questions, and then we'll go through as many as we can with the time remaining. And we do actually have quite a few here, so I'm going to go through these, and I'm basically assign it to either you, Jarno, or to you, Mohit, and or myself in order to take the to address these from the best folks that we have here. So, all right. First question, do I and my organization have to worry more about GDPR than the old DPA? I guess that's the previous law and regulation that GDPR is replacing. Jarno, you want to take that one?
Yeah, I mean, yes, you do have to worry more about it in the sense that, well, not only the financial risk brought in by the heavy fines, but also the reputational risk that comes with the GDPR. So yes, you have to worry more about the GDPR than the old Data Protection Directive. Yes.
So another leading question to that here, and this may actually touch upon a number of areas from a legal standpoint, from an organization strategy process standpoint as well as from a technology standpoint. So it sounds like, and again, the question here is, this is obviously a very important regulation for most companies that have to deal with this. Where do you start, right? At the end of the day, if the regulation is, the deadline's coming up and organizations haven't really prepared and thought about this, and now they realize that they have to deal with it, where do they start from a legal perspective? Start with going back to you, Jarno, on this.
Yeah. So I think, the first thing that any company covered by the GDPR is that they have to identify data, so it's more of a technical exercise. What personal data is stored in your system, processed by your company, where that data resides, because that's the key. You got to understand first what personal data you have in your systems. Then you start building compliance structures in place. So you build depending on your role, for example, if you're a vendor and your customer are looking for you to process their personal data, so you must be able to provide them with a credible data protection agreement that ensures that they can trust the personal data of their company with you, and making sure that you have proper technical and organizational data security measures in place to protect your customers' data. But it all starts with identifying the personal data in your systems, because otherwise, if you don't have that information, you can't provide access rights, for example, to individuals when they ask what personal data you have about them if you don't know where that data is in your systems. And similarly, you can't delete the data about a person if you don't know where it is in your systems. It really is about mapping, and then for U.S. companies, critically, you have to make sure that you have that compliance mechanism in place to move that data legally from Europe to the United States. So look at Privacy Shield, look at EU Commission standard clauses to move that data from Europe to the U.S. in a legal manner.
Mo, I call you Mo because I know you, Mo. So Mohit, on the program management side, you mentioned that Paradigm obviously provides services around this area. And again, going back to this question in terms of where do organizations start, if there is no defined program management process to deal with GDPR, I mean, where do they need to look, and what do organizations need to consider to get this going if they are subject to this regulation?
Yeah, I think the first thing, picking up on where Jarno just left off, which is this notion of the data protection impact assessment, right? It all starts with the data, so understanding where that data resides, what data currently exists, is it currently under control? And the only way to do this effectively, this is not a paper and pencil exercise, is to use tools, advanced tools to scan the environment and, as you indicated earlier, really look at the underlying values of the data. Is it a social security number? Is it a phone number? What data is it? Oftentimes, we find organizations have not looked at much of their data for years, in fact. And so understanding what the data is, where it is, what controls currently exist is the essential first step. Once that's in place, then you can perform another analysis that Jarno also mentioned, which is assess the risk. What processes currently act on the data? What is the lawfulness of that process? And then based on where the data resides, what data currently exists, what controls are in place, and the lawfulness of the processing, then you can build a program, prioritized program around what to remediate first, in particular as it pertains to access rights, right to be forgotten, and other subject rights that could potentially be invoked. One of the biggest challenges for most organizations, again, as Jarno just indicated, is the right to be forgotten. So if you don't know where that data is, then it's impossible for you to delete it. In many cases, it's impossible for a lot of organizations to simply remove such data. So different techniques have to be employed in order to anonymize or permanently anonymize some of that data where it cannot, in fact, be deleted. But these are some of the nuances that need to be built into the program, but it all starts with the data identification.
And also, just wanted to mention one thing that that is critical in this exercise is to identify all third parties that access personal data in that broadly understood sense. So, for example, if your company has, a number of web properties, number of mobile apps, which analytics tools, cookies, other software elements do those sites have? Because one of the things that GDPR does in terms of disclosure to consumers is that you have to identify those parties. And it often comes as a surprise that over the years, for example, the folks that have been working on your web properties or mobile apps have integrated all kinds of SDKs or APIs of third parties tapping into the data. So please make sure that you identify all those third parties that are accessing your company's personal data, and make sure that you have proper agreements in place with those third parties about how the data will be protected by them.
This is Peter. I think just kind of wrapping it up, a couple points. One is going back to the question, where do you start? Working with experts like Paradigm as well as Pulsanelli, in terms of assessing your readiness to comply with GDPR. I mean, point number 10 here on this slide that I'm showing on the Bright Talk Council, right? Data protection impact assessment. The companies like Paradigm and Pulsanelli can help organizations determine where are you and where do you need to be, and that will help determine where you need to make adjustments and investments. From a technology standpoint, as I mentioned earlier, the 4 areas that Informatica has supports solutions for data governance, obviously the identification of where sensitive data resides, consent management, as well as in the areas that we talked about with regard to anonymization as well as archiving. So if these are areas and solutions that your organization does not have maturity, you don't have solutions available today, GDPR may be the driver in terms of saying, okay, we need to invest in acquiring these solutions. But like anything, technology in itself doesn't solve everyone's problems, and technology alone is not going to deal with the complexities of ongoing compliance with GDPR and others. It's people, process, it's organization, it's culture as well. So keep that in mind. But again, the organizations here support the assessments. Informatica can also help in assessing your maturities around data quality management, data governance management, working with key partners like Paradigm. Another question here, and a lot of questions, it seems like, around the GDPR regulation itself. So Article 30 specifically addresses records of processing activities, or RPAs, which are artifacts documenting personal data. How does Informatica, I'm assuming here, address these needs for RPA? And I guess I can probably take that one on hand. So first of all, we're dealing Informatica from an Informatica solution standpoint. We're obviously providing technologies to address the data aspects of GDPR. A lot of times what we're finding is that some of the downstream issues that our customers face with regard to dealing with a regulation like GDPR or other regulations is the data is not ready for use. It's obviously corrupt. There's somewhere in the process from the time that the data got originated to the time that the data is being consumed that quality issues persist. We have data corruption that's going on. People don't know what the data means, who they need to go to for questions. Again, this is where solutions like our Axon for data governance is really helping organizations, first of all, define their policies, the definitions, the rights, the people who are involved in managing and governing those aspects of the data. And that's done through our governance solution called Axon. The other aspects of what we didn't talk about here in terms of identifying and addressing some of the root issues with the data that we're seeing in terms of data quality management. If you're not familiar with Informatica, for data quality management, we have solutions that are not designed just for the data warehousing developer to fix data that's being loaded into a data warehouse, let's say, that's being used to report on, to report and provide reporting for compliance requirements. But it also allows data stewards and analysts to really own the discovery and the identification of data quality errors not just in the source systems, but as data is flowing through the entire enterprise, and being able to develop rules to actually fix those issues. So Informatica data quality is a key component of that architecture. So what we're, again, providing is the mechanisms to gain access to the you need, define it, govern it for GDPR compliance, but also addressing the masking, the anonymization, and being able to determine who are those parties that you have to then protect and really care for in order to deal with this regulation. All right, let's see. Oh, great question here. Yep, I'm looking at the calendar. Today's March 29th. May 25th is right around the corner. If Paradigm is engaged to implement GDPR solution, is there enough time to have a solution implemented by the deadline? So a question for you, Mo. I mean, what do organizations need to do given the deadline is around the corner? What can you guys do to help?
Well, we can certainly help identify where the organization is today. So again, that starts with the data protection impact assessment, and then help formulate a program. Using the term solution is a tough term. It's very unlikely that anything's going to happen in an organization in 2 months. But what we can do is help identify what needs to exist, and then prioritize the work effort required to move the scale and move the needle towards compliance. So we can certainly have those discussions, put those program constructs in place, identify where the key risks are, in particular some of the organizational controls and risk mitigation strategies that should be in place that the regulator would want to expect to see the organization move towards, and then determine just how long it's going to take to remediate some of those key aspects. So that's how I would respond to that question.
Got it. So Jarno, there's an interesting question here, because we talked about masking and obfuscating data, anonymizing. But does GDPR also apply if an organization encodes or falsifies, or I guess pseudonymizes the data that they are using for their business?
Yeah, good question. As long as your organization has the key and can identify the person for your organization, that data is personal data. But if you pass on pseudonymized or anonymized data, then for that organization receiving that data, it's no longer personal data.
And then with the time remaining, this is one I'm also curious about, because I work a lot with chief data officers across multiple industries. But the role of a chief data protection officer, are you seeing more of those roles emerging, or companies just getting started? Just curious what you guys are seeing in the industry.
Well, Alan, I'll answer that from my perspective, the legal perspective, that yes, companies are appointing, we briefly covered there what types of companies have to actually appoint a data protection officer, but we're also seeing companies that, strictly speaking, don't have to appoint a data protection officer, appointing a data protection officer because it makes good business sense. They want to show their clients, that the customers, that they are putting an extra effort into being compliant, and having that dedicated role there is good. In terms of what types of individuals are being appointed to these roles, it's typically a combination of legal and technical background. CIOs are generally not seen as good DPOs, in the sense that they have often created those systems that are supposed to be critically analyzed under the GDPR. But again, it doesn't have to be a full-time role, depending on the intensity of the data processing activities you have, and it can be also an outsourced person. So there are vendors out there providing data protection officer services, and those are emerging as we speak.
Interestingly, I was just kind of thinking about the chief information security officer versus these chief data protection officer roles. Are they one of the same, or are they uniquely different?
Well, CISOs, Chief Information Security Officers, typically purely technical folks in the sense that they built their technical and organizational measures to secure information, the personal data the company processes, but then they often lack the legal understanding of the roles, which can be, you can get training on that, obviously, but there are usually separate roles. So you have a data protection officer and a chief information security officer.
Got it. Well, we are at the top of the hour, and I think we're running out of time, or ran out of time here. So first of all, Jarno and Moeed, I want to thank you guys for helping put together the content as well as executing the webinar today. And of course, I want to thank the audience who have spent their time here with us and listening to the speakers. And just to kind of wrap things up, as we mentioned, we will send you guys a follow-up email with links to both recording as well as copies of the slides from today's webinar. So with that said, I want to thank everyone. Have a great week and look forward to learning more and hearing more about what organizations are doing around GDPR. Thank you again.
Thank you.